Good morning, my lord. Good morning to all. Honorable
Good.
Srimati Justice B.B. Nagaratna, Judge High Court of Karnataka and President of the Karnataka Judicial Academy. Honorable Judges of the High Court of Karnataka and Board of Governors of the Karnataka Judicial Academy. Dr. Balram Gupta, Senior Advocate and Director of the Chandigarh Judicial Academy. All judicial officers of Karnataka District Judiciary and other states. Today, Karnataka Judicial Academy organized this webinar in collaboration with the able assistance of SEC Online on Judicial Culture in Aid of Rule of Law. The program is the brainchild of our beloved President, Honorable Srimati Justice B.B. Nagaratna, Judge High Court of Karnataka and President of the Karnataka Judicial Academy. On behalf of all of you, I wholeheartedly welcome our beloved President, Srimati Justice B.B. Nagaratna, Judge High Court of Karnataka. Welcome you, Madam.
Thank you.
On behalf of the Karnataka Judicial Academy and on behalf of all of you, I wholeheartedly welcome Honorable Judges of the Karnataka High Court of Karnataka and Board of Governors of the Karnataka Judicial Academy. Welcome you, my lordship. On behalf of Karnataka Judicial Academy, on our invitation, Dr. Balram Gupta, Director of Academies of Chandigarh Judicial Academy, Senior Advocate, having 5 decades of legal experience as academician and senior advocate as a trainer of the National Judicial Academy, has accepted to address our officers. I wholeheartedly welcome you, sir.
Thank you.
On behalf of the Karnataka Judicial Academy, I welcome all the judicial officers of Karnataka State and other district judicial officers of the other state. And on behalf of the Karnataka Judicial Academy and personally, I wholeheartedly welcome Sri Chetan Singh Gill for providing able technical support in organizing this webinar. Welcome you, sir. Now, I request our President, Honorable Srimati B.B. Nagaratna, Judge High Court of Karnataka and President of the Karnataka Judicial Academy to address introductory address and handing over to Honorable Justice Srimati B.B. Nagaratna.
Thank you. A very good morning to everybody. My esteemed sister and brother judges of the High Court of Karnataka and other High Court judges who have logged in. Dr. Balram Gupta, learned speaker of today's webinar on Judicial Culture in Aid of Rule of Law. The directors and other officers of all other judicial academies of the states, learned and my esteemed judicial officers of Karnataka and all other states, Mr. Chetan Singh Gill of SEC Online. On a second Saturday morning, we have a very interesting topic to listen to and debate upon. I personally think that it is not going to be a waste of time as such, but of real importance to spend our time, particularly during the lockdown. Now, to preface Dr. Balram Gupta's address, I would speak a few minutes. We as judges know that justice should not only be done, but it should be manifestly seen to be done. It is on this principle that the proceedings of courts of law are open to the public, except in those cases where for special reasons the law requires or authorizes a hearing in camera. Justice can never be seen to be done if a man acts as a judge in his own cause or himself is interested in the outcome. This principle applies not only to judicial proceedings, but also to quasi-judicial and administrative proceedings. Now, I thought it apt to quote Justice Kuldeep Singh in State of Karnataka versus Appa Balu Ingle, 1995, Supplementary 4 SEC 469, when he said, and I quote, "Judges are participants in the living stream of national life, steering the law between the dangers of rigidity on the one hand and formlessness on the other hand, in the seamless web of life. The great tides and currents which engulf the rest of men do not turn aside in their course and pass the judges idly by. Law should subserve social purpose. Judge must be a jurist endowed with the legislator's wisdom, historian's search for truth, prophet's vision, capacity to respond to the needs of the present, resilience to cope with the demands of the future, and to decide objectively, disengaging himself or herself from every personal influence or predilections. Therefore, the judges should adopt purposive interpretation of the dynamic concepts of the Constitution and the law, with its interpretative armory to articulate the felt necessities of the time. The judge must also bear in mind that social legislation is not a document for fastidious dialects, but a means of ordering the life of the people. To construe law, one must enter into its spirit, its setting and history. Law should be capable of expanding freedoms of the people, and the legal order can, weighed with utmost equal care, be made to provide the underpinning of the highly inequitable social order. Though the aforesaid words were stated in the context of the power of judicial review, I think those words are equally applicable to all judges who are in the process of adjudication. Now, when we come to judges, the ideal is what Socrates aptly described as the essential qualities of a judge. They are repeated often, not only in the Karnataka State Judicial Academy, but I am sure at all judicial academies across the length and breadth of the country, namely to hear courteously, to answer wisely, to consider soberly, and to decide impartially. These words were spoken by him about 2,400 years ago. Fortunately, in our country, we have excellent judges, while on the bench, they have exhibited exemplary temperament. They remain calm and collected and treat all who enter the courtroom with the dignity and respect they are entitled to. Indeed, such judges are a credit to the bench and to the judiciary of the country. It is in the above context that we have organized this webinar on judicial culture in aid of rule of law. Just a sentence or two about rule of law. I'm not going into the nitty-gritties of it, but according to Augusto Zimmerman, the associate lecturer of the Murdoch University School of Law, he has complied the principles and institutions which are requisite for the realization of the rule of law. And the important of these, I would only say, laws against private coercion. Law should be clear, certain, adequately published, and normally prospective. The rule of law implies a certain generality of law. Law should be as stable as possible. Laws limiting, controlling, and guiding the exercise of official discretion must be clear. The courts must be independent, impartial, and accessible to everyone. The rule of law stands in opposition of extemporary decisions expressing the mere personal will of individual judges. According to him, regardless of which conception of the rule of law is embraced, its practical achievement may require a proper culture of legality. Governments that eschew the rule of law are always prepared to use naked power to achieve their political aims, although they will not allow themselves to be subject to a constitutional system of checks and balances. The rule of law can only subsist where there is a proper constitutional framework, coupled with a culture of legality, which places a high value on the ideal of government under the law. In the absence of this social perception of legality, a government can even draft a very sophisticated rights-based constitution, but this in and of itself will not ensure that constitutional rights will be seriously respected. They may in actual practice be worth no more than the paper on which they are written. It is for the implementation and manifestation of the rule of law in the society and in the country that the role of the courts assume importance. And when I speak about the role of the courts, it would ultimately mean the role of the individual judges. And when we speak of the role of the individual judges, the judicial culture in aid of rule of law would assume significance. That is the topic on which Dr. Balram Gupta, with his vast experience of over 5 decades as a senior advocate, as a law teacher, and as a director of the National Judicial Academy, who has seen in any number of judges in and out of office, and young judges, middle-aged judges, and senior judges throughout his career, and who is presently the director of the Chandigarh Judicial Academy, has been invited to speak to all of us today. With this short introduction and without anything further ado, I now request Dr. Balram Gupta to commence his address. Thank you.
Thank you so much for such a wonderful introduction to judicial culture and rule of law. Honorable Srimati Justice B.B. Nagaratna, Honorable Justices of the Karnataka High Court, the Director of Karnataka Judicial Academy, the judicial officers of the Karnataka Judicial Academy, the Karnataka state as such, Mr. Gill, and the Kupasnari of law and justice across the country. It is always a pleasure to be on this platform, particularly with the Karnataka Judicial Academy. It seems there is a bond with the Karnataka Judicial Academy, which I continue to cherish as such, and would continue to look forward of this bond, of this association with the Karnataka Judicial Academy, and in particular with Justice Nagaratna. Having said that, my romance with rule of law started way back in 1969, when, as a young law teacher, I joined the Punjab University, and I used to teach rule of law in the domain of administrative law. I explained rule of law as the handsome son of an ugly mother. Excuse me for using this particular expression, but it denotes as to why and when the rule of law is required. The mother reflects in what situation the rule of law is required. The situation which is lawless, no order, chaotic situation, disorderly society as such, the birth of rule of law takes place. And the consequence of the rule of law, when it takes its birth, is reflected in handsome son. From disorder to order, and from chaotic situations, it emerges as an orderly society as such. And therefore, in that particular context, when we talk about rule of law, I am not going into the consequences, what Dicey had said about this concept. I am on the practical pedestal for that matter, and not going into the concept given by Dicey and others, for that matter, over the decades. The two words, rule of law. Who rules the law? That is, in a system where there is rule of law, it is the law that prevails, the law that actually operates as such. We say law is the king of kings. And that means what? Even over the king is the law that rules, for that matter. This is actually the requirement if we want to run the system in an effective, disciplined manner, for that matter. Rule of law in a country is reflected in the Constitution itself. We talk of who is supreme in our system. Is it the Parliament? Is it the executive? Is it the judiciary? The answer is, it is the Constitution which is supreme as such. Why do we give a Constitution to run the system, for that matter? The answer is straight and clear. And that is that in a system of rule of law is the Constitution which controls, regulates every activity of the state system as such. There is always a dialogue as to whether the Parliament, like the British Parliament, the Indian Parliament, is supreme, for that matter. Yes, Parliament is supreme within the discipline of the Constitution. The Constitution is the rule of law. It controls all legislative actions of the Parliament. Similarly, the executive is regulated by rule of law. It has to actually and factually be within the rule of law. The judiciary has been given the role of the interpreter, the final interpreter of the Constitution. And therefore, it is the judiciary which monitors whether the Parliament, the executive, is functioning within the rule of law or not. And that role the Constitution assigns to the judiciary. It is in this context that the role of the judges at all levels, be it at the district level or the High Court level or the Supreme Court level, what has to be ensured by the judiciary to uphold the rule of law. It is this upholding the rule of law is the major role that is being played in order to ensure that each organ of the state remains within the discipline of the Constitution. Therefore, it is the courts, the judges, who have to maintain and uphold the rule of law under all circumstances as such. Going a step further, what is rule of law? Any law which is enacted Is that binding? And can it be said that whatever is the law laid down, whatever is the procedure laid down, if it is followed, the judges have to uphold that? I would add a caveat here. Yes, the rule of law what it is as such. The question is whether any law could be said to be part integral of rule of law or not, arose before the Supreme Court right in the beginning, 1950, in A.K. Gopalan's case. Procedure established by law in Article 21. Preventive detention. And therefore, the Supreme Court at that particular point of time, right in the beginning, comprised of 6 honorable justices. And this matter was considered by the full court, for that matter, all the 6 judges. The majority view 5-1, with Justice Fadl Ali dissenting as such. Procedure established by law, it was said, whatever is the procedure laid down under the law, that is to be followed. That is the rule of law, and that is to be carried forward. Whereas Justice Fadl Ali dissenting said every law cannot be said to be the rule of law as said. The law has to be tested on the touchstone of the Constitution, number 1. And the law has to be tested on certain basic fundamentals as such. A dictatorial law cannot be said to be as the rule of law for that matter. And in that particular context, this journey from A.K. Gopalan in 1950, we traveled to Maneka Gandhi in 1978, where the view taken by the majority of the Supreme Court, that majority view was not accepted. Procedure established by law, it was held in Maneka Gandhi's case, means such procedure which is reasonable, just and fair. Now here it is what the role which the judiciary plays in making the law meaningful, in making the law wholesome, in making the law which actually should be the rule of law for that matter. Maneka Gandhi's case, the passport was impounded. Why? It was suspected that the person concerned may run out of the country and was required to be in the country present as such. That is prior to the internal emergency situation which was there. Now, her passport was impounded without any notice, without any kind of opportunity given to the party concerned. When the matter came before the Supreme Court, it was considered, the argument on behalf of the government was, we have followed the Passport Act. The passport can be impounded without any notice because it does not stipulate any opportunity or notice to be given to the party concerned. And once we have followed the act itself, it cannot be said that we have acted contrary to the rule of law. It is this particular background that the Honorable Supreme Court introduced the concept or the principle of pre-decisional hearing to be given to the party concerned. Normally, we know of post-decisional hearing. But in a situation like this, the government's argument was simple and straight. If we give the notice, the party may run out of the country, go out of the country. And the very purpose of the action which is contemplated to be taken in public interest will not be possible to be done as such. It is in this background that the procedure established by law was interpreted only such procedure which is reasonable, just, and fair. If no opportunity is required to be given, in that situation, what would happen? That injustice may be done. And what the Supreme Court held in this case was pass a temporary order suspending the passport, give an opportunity to the party concerned. And if the party gives an undertaking that she will not go out of the country, then release the passport. Meaning thereby that they brought in this particular aspect, that rule of law means not any law which is enacted. The law as enacted has to be tested on the ground of the Constitution, on the ground of reasonableness, fair and justice to be carried out. Having said this, in the domain of rule of law, and particularly in the domain of the Constitution, one of the major issues is that the Parliament carries out the will of the people. Any law which is enacted by the representatives of the people across the country in the Parliament, they represent the will of the people for that matter. And it is the will of the people which is supreme. Any law which is enacted by the Parliament, therefore, in that context, would be deemed to be supreme. Now, it is here that we have to understand rule of law in the right perspective. The Constitution itself carries the will of the people. The will of the people does not change with the change of government. The basics of the Constitution are sacrosanct, as laid down in Keshwananda Bharati's case. And therefore, the Parliament cannot possibly take the alibi and shelter behind the issue of the will of the people. The will of the people doesn't change with the change. It is contained in the Constitution. The basics of the Constitution cannot be changed. And it is in that particular context that we have to look into the entire aspect. Rule of law is to be implemented by the judges. Judges are human beings. They deal with human problems, disputes, issues as such. They're required to deal with them in a humane manner, for that matter. And therefore, the judges, while upholding the rule of law, they do not act as the computers, feed the factual canvas, feed the law, and get the order as such. That is not what is possible. It's very easy to say rule of law. Be you ever so high, the law is above you. It's easily understandable. Law does not propel of its own. It's the human agency, it's the judges who make the law, the rule of law, as the rule of life for that matter. This is most important. Judges put life into rule of law, in molding, in dealing with different situations. And this role of the judges in upholding the rule of law, in making the rule of law as the rule of life, they have to play a very significant role. My emphasis is on that as such this morning. Having said this, I go a step further. Come to the judicial culture. I have been thinking, contemplating, writing, discussing, speaking about that what kind of a role the judicial culture plays in upholding the rule of law. I said that judges play a significant role in making the rule of law as the rule of life. And therefore, the judicial culture blends itself in order to enable the judges at all levels to actually play that particular role. What is judicial culture? And it is in that context, when we talk about culture, it's an amalgam of many factors, of many aspects as such. The Western culture, the Eastern culture, and similarly we talk of the judicial culture as well. Recently, I wrote a piece on this very topic, judicial culture in aid of rule of law, for the Chandigarh Judicial Academy newsletter. And permit me to refer to what I said about the judicial culture. What is judicial culture? It is the sum total of features which shape the way in which judges are required to perform. It is judicial culture which shapes the minds of judges. It is the judicial discipline which helps the judges in cultivating habits which form part of their personality, to hold the court on time without fail, never to rise from court before time throughout the day. Hear the parties courteously, measure judicial communication, cool mind, no anger, no ego, the atmosphere in court comfortable and congenial. A judge always wanting full assistance from the lawyers. The lawyers equally willing to assist the court smooth two-way traffic. No accidents, only incidents. And meaningful incidents, wit and wisdom be the part of court. In short, judicial culture means both lawyers and judges be happy minds, cultivate happy minds. It is only the happy minds which can uphold the rule of law. Judicial culture and discipline are the best tools and the aid of rule of law. This is how I perceived judicial culture. You know, Socrates, as Justice Nagaratna had pointed out, had given us a four-way test, which actually is the test of judicial culture as such, in that context, for that matter. Hear courteously, consider soberly, answer wisely, decide impartially. This four-way test sums up the entire judicial culture. Hearing to be given, but if the judge's mind is not cool, is not courteous, and just a formality being carried out, you're not considering the matter soberly, effectively. You are not responding in a responsible manner, answering wisely, and of course, deciding impartially. These four factors actually play the major role in upholding the rule of law. See, it's not blindly to apply the law or to uphold the law. The entire process, the process of doing justice, the process of decision adjudication as such, is blended with judicial culture. Only then and then it becomes possible, a reality for that matter, to be carried out effectively in that context as such. You know, the weaponry of judicial culture is very strong. You would ask me, what do I mean by that? Take the principles of natural justice. That is the best barometer of judicial culture. To do justice automatically, naturally, what do you require? Two basic components. One, who judges the mind of the judge free from prejudice, free from bias, free from any kind of aspect which really would tinker with doing justice impartially as such. That's the basic principle of natural justice, doing justice for that matter. Now, even if I uphold the rule of law, but my mind is prejudiced, my mind is not actually what it ought to be in that context, it would make all the difference for that matter. Similarly, hearing the parties, it's not a formality, it's a reality if you wish to make and uphold rule of law as such. It is this basic principle of natural justice which helps you to actually uphold the rule of law in that context. You know, Magna Carta, more than 800 centuries back, three things were said. Justice is not to be sold. Justice is not to be delayed. Justice is not to be denied. This threefold recipe centers around, on the one hand, the principles of natural justice, and on the other hand, the rule of law. It is blending both the aspects together. Then alone it becomes possible then alone it becomes easily possible in the sense to carry it out, to uphold the rule of law in that context. You know, take the case of a fair trial. It is always said the trial judge is on trial throughout the trial. A trial judge has to maintain neutrality throughout the trial, for that matter. It is this neutrality, the fairness of the trial throughout, for that matter. These are the integral components of judicial culture. Sans these components, can we actually uphold the rule of law, for that matter? The judges have to tune their minds, train their minds into this cultural fabric which would ultimately help them in carrying forward, upholding the rule of law in that context. When I talk about the fair trial, let me refer to Kasab's case. What happened in Bombay in the year 2008, on the law day, the constitutional day, 26th of November, way back in the year 2008. 166 killings took place. The trial was conducted expeditiously and in accordance with rule of law. The matter goes to the High Court, from the High Court to the top court of the country. And the top court had a hearing for 13 long weeks in that particular matter. It is recorded in the judgment that the lawyers not even once raised their voice. They argued and argued whatever they wanted to argue, but with a cool mind as such. And it is recorded in that particular judgment that the trial judge was actually the torch bearer of rule of law. That the whole trial was conducted in accordance with rule of law, in spite of the fact it was such a difficult situation. And keeping in mind the fact that the entire trial was absolutely in a fair manner conducted, the Honorable Supreme Court directed that the trial record, which runs into thousands of pages, should be photocopied, bound, and kept in the National Judicial Academy. We have the entire trial court record in the National Judicial Academy in Bhopal, in order to demonstrate that how a trial needs to be carried out, even in such kinds of cases, for that matter. That speaks volumes for the trial court judge. This is the kind of trial court judges that we need in the country. And I'm sure the judiciary across the country, the trial judges across the country, are actually the torch bearers of rule of law as such, for that matter. You know, it is this kind of a situation, this kind of a background, which actually makes the whole difference in that context as such. Judicial culture is like the rainbow. It has many colors, shades for that matter. but it is universally the same. In the sense, from Kashmir to Kanyakumari, from Goa to Gurugram, and from India to UK to USA, and for that matter, the common law systems, the civil law systems, judicial culture is the same for that matter. This universality of the judicial culture is the actual recipe which needs to be inculcated in the judiciary at all levels in that context. This is actually very important. It is in that context that since judicial culture is the same in different cultures, Western, Eastern cultures, judicial culture remains the same. And therefore, it is only because of that the rule of law becomes actually workable, accessible in that particular context, in that background. Now, going a step further, we talk of judicial culture. Let me refer to Article 142 of the Constitution. The Supreme Court can pass any order, give any direction, pass any decree, in order to do complete justice. I correlate doing of complete justice is a part integral of judicial culture as such. How do I correlate the two? For instance, if there is a law which comes in the way of doing complete justice, the mandate of Article 142 is that you must do complete justice. Now, if the top court, the apex court of the country feels that a particular provision of law is hindering the doing of complete justice, on the one hand, the Parliament says, this is the law that we have enacted. This contains the will of the people for that matter. On the other hand, the apex court feels that this provision is an hindrance in doing complete justice. And therefore, that particular law is not in accordance with the mandate of Article 142. The rule of law demands that complete justice must be done. Let me give you this example of COVID-19. But for Article 142, we were facing a real hard situation. And the Honorable Supreme Court dealt with this matter under Article 142. COVID-19 situation. Could the courts be closed down? Under no circumstances. And therefore, acting under Article 142, the virtual court system was evolved, so that at least to an extent, the accessibility to courts could be possible. This is integral to judicial culture. This is integral to upholding the rule of law for that matter. Everything else was shut down. The courts could not be shut down for that matter. And therefore, resorting to Article 142. Similarly, it was impossible for the people to approach the courts in various matters. For that matter, the limitation law. The limitation expires, say within 3 months or 90 days or within 3 years, whatever the situation. Acting under Article 142, the Supreme Court passed an order that the limitation law will not be the limitation as such till further orders. This is molding the relief. This is part of judicial culture in that context that needs to be actually kept in mind in that context. You know, COVID-19 one situation, the crowding of the prisons for that matter. Again, acting under Article 142, how meaningfully the direction was given to the states to constitute high-powered committee to consider that in what kind of cases the prisoners, the under trials, could be put on parole for that matter, or given the bail for that matter. In no other system, this particular jurisdiction of Article 142. And imagine the kind of situation which COVID-19 had put to us as such. Is it not part of the judicial culture for that matter? Article 142 has become an exportable item. Some of the other systems, later constitutions, have introduced full justice, complete justice, these expressions. And it is here the role of the judges actually comes into. It is here when they have to blend complete justice and rule of law. How they really carry it out. That is what is actually the context as such. You know, one of the aspects of Article 142, the limitation which we face is that it is only the top court which has this jurisdiction, neither the high courts nor the district courts. Absolutely understandable. You know, the law laid down by the Supreme Court is binding under Article 142 on all as such. And in fact, while invoking Article 142 during this particular pandemic times, the Apex Court also resorted to Article 141. And therefore, once the Supreme Court lays down the law, even in other situations, interpreting different laws for that matter, that law is binding on the high courts and on the district courts for that matter. You know, many a time an issue is raised. Is the Constitution relevant to the district judiciary? It is normally said the district judiciary deals with various legislations, the Civil Procedure Code, the Criminal Procedure Code, the Indian Evidence Act, the Penal Code, and variety of other codes and legislations. The district courts don't issue writs for that matter. And it is said, oh well, there's no relevance of the Constitution. I faced this situation when I was at the National Judicial Academy. And I introduced, particularly for the district court judiciary, a session or two on the relevance of the Indian Constitution to the district judiciary. The district judiciary plays a vital role in upholding the rule of law, the grassroots for that matter. And in that context, if their connectivity with the Constitution is not there, and the very relevance of the Constitution is questioned, you know, Supreme Court over a period of 70 years and plus have laid down, interpreted variety of legislations. The district court judges have to apply all what has been interpreted by, even if they don't issue the writs, yet the basics of the Constitution govern the different legislations. The latest judgments of the Supreme Court, they are so relevant and binding on the district judiciary. I'm emphasizing this aspect particularly, that the judicial culture which needs to be developed at the level of the district judiciary, the vision of the Constitution, the relevance of the Constitution, is again a part of the judicial culture. I extend it in that context. And therefore, that would help the district judiciary across the country to actually carry out the entire situation in an effective manner for that matter. Now, judicial culture, it was being pointed out. Judicial temper is an integral part of judicial culture. You know, Lord Denning says one thing which a judge should never lose: temper. They are judges who are cool, who you will not find them in court losing their temper. They are calm, quiet, and yet firm and effective, which is most important. Let me share with you an incident which happened in the Punjab and Haryana High Court. Justice Rajiv Raina, in the morning, the admission matters were being taken up. It so happened on a given day, the first 4 matters, they were dismissed. When the 5th case was taken up, the lawyer says, I urge for an adjournment. My lord is in an angry mood, in a dismissing mood for that matter, and therefore I wish not to take a chance. I want and I request, adjourn the matter. The Honorable Judge adjourned the matter by recording that this is the request which has been made by the learned counsel. However, I record that all those 4 cases were not having merit to be admitted. Case adjourned to such and such date. Now the question is, should the judge have made this adjourn the matter or not? I would like to take up this aspect when we come to the discussion part of it. But the point is that temper plays a very significant role, and therefore it is an integral to judicial culture. You can't uphold the rule of law if you are in an angry mood, and you cannot actually, in such a situation, do all that as such. Let me share with you another incident. It happened in the Honorable Supreme Court. A case was being argued and was being argued by a person, in person as such. In a situation, he raised his voice. The Honorable Justices asked him not to raise the voice. And still he continued in that raised voice. Maybe that he was used to it, or maybe that he did not understand the situation as such. When the judges found that he was not listening to what they were saying, the orderly was asked to remove him out of the court. Fali Nariman was sitting in court at that time, and he told the orderly not to touch him. He was taken out of the court, and the case was dismissed. This case has been recorded in the autobiography of Fali Nariman, Before the Memory Fades. And he says in the evening he went over to the residence of the then Chief Justice, Justice V.N. Khare, and shared what had happened in court. The next day, the Honorable Chief Justice of India called that particular person. The case was restored and was adjourned to be argued before the same bench on a different date as such. Now, see, this is what really actually is upholding the rule of law for that matter. Even in district courts and any other level of courts, situations come up when there is a confrontation between the lawyer and the judge. All that kind of a situation needs to be monitored effectively. You know, judicial minds are nurtured minds, cultured minds. They use measured language. This all is part of judicial culture. Inside the court, outside the court, this culture needs to be reflected in that very context as such. I share another example, actual happening. I don't know whether I shared this when I spoke last time on April 4th as such. You know, in London Times, a story appeared under the caption, Old Fools. The photographs of 3 members of the House of Lords, and over that, Old Fools, and the story in that. No action was taken. One of the members of the House of Lords happened to come to India later on. Fali Nariman met him and asked him that this is the story that appeared in London Times. You did not issue any contempt notice. Why? After meeting and getting the response was that member of the House of Lords says, old is a matter of fact. Fool is a matter of opinion. What was there to issue the contempt notice? You know, it is in that context, how cool minds. When Fali Nariman wrote an article in the Indian Express, sharing this aspect, that one has not to be that sensitive. Take the things in a manner in which they ought to be and not to be agitated for that matter. That's part of the judicial culture. I'm talking about the lawyers. You know, recently in the Gujarat High Court, particularly that particular lawyer's case, the senior advocate, Yatin Oja, a senior advocate, president of the Gujarat High Court Bar Association, member of parliament, he would lose his temper repeatedly in court. Alleged corruption, alleged favoritism to the judges as such. And the judges decided to take off his designation of senior advocate. The matter came up before the Supreme Court. And when the matter came up before the Supreme Court in that context as such, Honorable Justices S.K. Kaul and Justice Subhash Reddy, they were dealing with this particular matter. And you know, they put it across to him that you are gifted with such skillful skills of a lawyer. You are a knowledgeable man. You articulate so well. This is the gift that you have. And yet you misuse it. Yet you lose your temper. You get angry and allege every kind of thing as such. He was reminded that certain things happen when the facts are not on your side or the law is not on your side. Here, the facts and the law are with you, and yet you behave in that particular manner. You know, this is a situation which actually is a challenge, and ultimately is the rule of law which suffers. Angry minds, maybe the lawyer, maybe the judge, they cannot decide as per their judicial mind for that matter. And therefore, in that context, I normally say that the atmosphere in the court, which is a part of judicial culture, a lawyer should feel comfortable to assist the court. You know, some courts are tense courts. You would ask me, why do I use the expression tense courts? The judges, the temperament, and therefore the tenseness flows in that environment. Trust me, as a lawyer, you can't give your best if the environment in court is not congenial, is comfortable as such. Lawyers wish to help the court, assist the court effectively. And similarly, the lawyers, when they do not behave, conduct themselves in a manner, it is ultimately the rule of law which suffers in that context, in that background as such. You know, a rule of law must percolate, must continue in all different situations. Let me take the example of the internal emergency in the year 1975, 26th of June, which was lifted on 21st of March, 1977. Now that was the time where it was felt that the rule of law was adversely affected. Let me share with you a particular thing what happened in the Bombay High Court during that particular period. A meeting was organized which was to be chaired by the former Chief Justice of Bombay High Court, Justice M.C. Chadla. And other lawyers and judges were to participate in that meeting. The former judges and the lawyers for that matter. The state of Bombay, Maharashtra, passed a prohibitory order saying that this meeting will not be held as such, prohibited that meeting, not to be. That was challenged before the Bombay High Court. That prohibitory order was challenged before the Bombay High Court. The Chief Secretary of Maharashtra filed an affidavit justifying the prohibitory order. Ram Jethmalani argued that matter, and he sought the permission of the Honorable Judge to cross-examine the Chief Secretary. The permission was granted. The main basis of that particular prohibitory order was that this meeting can be a threat to the security of the state during that emergency as such. Ram Jethmalani cross-examined him, shattered him, and ultimately the prohibitory order was struck down by the Honorable Bombay High Court. Now it speaks of what? The judicial culture. Even if it was an extraordinary situation, the law is not silenced. The rule of law is not silenced as such. The law continues to be operative in that particular context for that matter as such. That is what actually the situation was. Recently, a case came up before the Honorable Supreme Court, Election Commission of India, wherein the two justices, the Chief Justice of Madras High Court and another companion judge, made certain observations while dealing with the case relating to the Election Commission as such. In fact, what was said in the matter as such, observed by the Honorable Division Bench, that this present situation of COVID-19 is as a consequence of the Election Commission, and it needs to be prosecuted for murder for that matter. Harsh words, something which was avoidable as such. In the final order which was passed by the Honorable Division Bench, these observations were not recorded. But these observations came in print media, electronic media. They were flashed across. And the Election Commission went to the top court, the Supreme Court, saying that their main grievance is the oral observations made by the Honorable Division Bench and not with the final order that had been passed, because it had not been recorded in that. You know, a bench of two judges of the Honorable Supreme Court, and the judgment has been authored by Justice Dr. Dhananjay Chandrachud. What a balanced way it has been dealt with. They have said so in so many words that these were harsh words. The metaphor was inappropriate as such, and therefore it should not have happened. It should not have been observed in that manner. But recording of that coming in print media, we have an open court system. And if certain observations have been made by the honorable bench, we would not put a restriction, stop that to be in media for that matter. What is that open court system if the reporting is not to be open for that matter? It is a part of judicial culture. But equally, what the Supreme Court pointed out, which is most significant, open court system introduces certain basic limitations, which are integral to judicial culture. You know, the language which is to be used. Judicial restraint is the exact expression which has been used by the Honorable Supreme Court. Whatever you are judicially communicating, observing in court, it should be in measured language. Otherwise, it makes a dent. In fact, the basic argument of the Election Commission of India was, we are also a constitutional body. Can a constitutional body be treated in this particular manner? I am confident that the Honorable Madras High Court did not intend attribute actually to the Election Commission in that manner. It is the background in which what all had happened, the elections and other things, and COVID-19 situation, which prompted. Judicial restraint means whatever be the situation and whatever be the level of the judges, they have to maintain and articulate, speak out in a very measured language. It is the judicial conduct which matters. You know, the Supreme Court has said judicial restraint ultimately means judicial respect for the other constitutional bodies. You know, it is in this context, in this particular background, respect for the other constitutional bodies. What the Supreme Court says, yes, if the action of the other constitutional bodies is illegal, unconstitutional, strike it down. But you don't have to give vent to your emotions. Control yourself, restrain yourself, show respect to the other institution, the individual for that matter. See, these are all integral to judicial culture. You know, I look at from this angle, from this aspect as such, that the rule of law is very easy to understand and also easy to uphold. But human situations, the human disputes are to be actually punctuated with judicial culture. Harold Lasky had written a letter to Justice Holmes. And in that letter he says, how much I wish if the people could understand that judges are human beings. Justice Holmes wrote back to Herod asking, how much I wish if the judges could understand that they are human beings. After all, it's the human agency. And this human agency, the judicial culture, nurtured in that culture, for that matter. It is the judicial academies across the country, including the National Judicial Academy, shaping the future judges on the threshold of judicial culture. Knowledge of law, application of law, understanding of rule of law, all very important, no doubt about that. But unless you actually mix it, blend it with judicial culture, rule of law would not be actually a possibility. It may become an impossibility in the sense that you have to blend the rule of law with judicial culture. It's this judicial culture which is the strength of the entire judiciary, across the world for that matter. You continue to be trusted by the public, by the people. They have trust and confidence in this institution because they know that the rule of law would be upheld, mixed with judicial culture. I would only add, think of rule of law without judicial culture. I pause for an answer. Thank you so much. I'll be very happy to have your questions, doubts, issues that you have in your mind. I don't know whether I have been able to generate something which would be meaningful as such.
Thank you, sir.
Thank you.
We have got one question
Yes.
from Hyderabad. Dr. Kiran Kumar, D. Kiran Kumar, Senior Civil Judge, Hyderabad, Telangana. He asked, Honored Sir, the trial court judge is a judicial interpreter and not the judicial legislature. His only task is to apply already established law to the facts. What should be his judicial culture at the time of exercising discretion, whether a trial judge can show partiality towards the constitutional mandate or to uphold the rule of fearlessly?
You know, a trial is a component of many parts. And therefore, in that particular context, that impartiality would come only in the end when the matter is to be decided. I would not agree with that aspect. The reason being simple. Recording of evidence is very important. And then each element of the trial, for that matter. Why the Kasab's case trial, the trial judge was said to be the torchbearer of rule of law. You know, each component of the trial is again regulated by different provisions of law. And therefore, a judge on dealing with the trial for that matter has to actually throughout be neutral, and then on the basis of what has come on record, finally decide that matter impartially in a neutral manner. That's how I would look at that.
Thank you, sir. one anonymous messages came. Very impressive, educative, useful lecture, sir. Advocates also must listen to the lecture.
Thank you for that.
That is one suggestion. Yes.
Yes, what?
Another question, sir.
Yeah.
The name is not mentioned. I am Dr. Suman Srinivas Reddy, first additional district judge, Telangana district, sir. Most of our civil and criminal procedural and substantive laws conform to the rule of law. Hence, it is necessary to stick to the principles of natural justice and to the unwritten principles of rules of law while administering a justice to the consumers of a justice in the lower courts.
You know, question is rules of natural justice are unwritten rules for that matter, unwritten principles for that matter. They supplement the law, not supplant the law which is there. Principles of natural justice, trial court judge. See, natural justice says no bias in the mind of the judge. Now, yes, the judge has to apply the law, but should be free from any prejudice, any kind of bias for that matter. Question is, you can't say that the principles of natural justice are not applicable at the trial court level for that matter. Certainly not that. For instance, a lawyer is not given a proper hearing. Even if you decide the matter in accordance with the law as such, yet in that context, if the lawyer has been denied a hearing, why do we say a courteous hearing? Only because of the fact that natural justice principles support and help in doing justice in a natural manner. You don't have to punctuate principle of natural justice into the law as such, but each action of yours in court dealing with that particular matter has to be in accordance with principles of natural justice.
Thank you, sir. A trial court judge, while deciding the controversy involved in issue, can he interpret the law?
You know, a trial court judge finds himself in controversy with law as such. You're saying that?
Yes.
You know, it's not the right way to say this. Why a trial court judge would find himself or herself in controversy or in conflict with law? I have heard of children in conflict with law, but not the trial court judges in conflict with law for that matter. See, let me put it this way, let me add to this. I'm sure what the honorable questioner who is asking this question actually means what? That the law comes in the way of conducting that particular trial. See, over a period of time, the High Courts and the Supreme Court has interpreted different legislations. A trial court judge has to be up to date. I'm sure such situations which come before the trial court judge have been dealt with over the decades in variety of matters, and I do not see. Secondly, if he feels or she feels that there is a conflict with law, let that particular judge decide that matter. What that judge actually feels about that. No judge is born who has never committed a mistake for that matter. Honest mistakes are committed as such. It should not be intentional for that matter. And if a mistake has been committed, we have the system of appellate jurisdiction, of revisional jurisdiction, where it could be rectified. And once you have decided, let it not bother your mind. That is a part of judicial culture. Decide what you feel genuinely about that matter. And even if it is wrong, no motive can be attributed to you. It has not to be intentional at all under any situation for that matter. And therefore, one should not feel that one is in conflict with law. One can be in conflict with one's conscience for that matter, but not in conflict with law. I'm looking forward to Justice Nagaratna's. I'm sure you must be having some issues in your mind to share. Can't hear you.
My lord, you are not audible.
Yes, now you're audible. No.
Santosh, madam ಅವ್ರು ಕೇಳ್ತಾ ಇಲ್ಲ.
Naratna ma'am, your mic is muted. Just click on the mic button. The mic button would be on the top, on the top right side, next to your video icon.
Gil sir, you have not enabled madam's. It is disenabled.
Just a minute. Now, ma'am, now please see it, ma'am. Okay.
My lord, please click unmute the mic.
Am I audible now?
Yes,
madam. Yes, madam.
No, possibly the last question was in the context of the predicament of a trial court judge or the judge at the district court level when there is a conflict in judicial precedents, and then in what context, then how the conflict could be resolved by the trial court judge or the judge at the district court level to achieve rule of law in that particular case.
I quite see that issue as such, and I'm sure my Lord Justice Nagaratna is far more competent to respond to this question. I, of course, would do that, but I'm sure with your practical experience, you know, conflicting judgments, yes, understandable, and that does happen at times as such. Now, in that context, for instance, there are two conflicting judgments of the High Court itself, of the concerned state as such. Normally, we would say the later judgment is to be followed by the trial court judge or the district court level as such. Now, assuming the earlier judgment, which is in conflict with the later judgment, was not even considered or referred in the later judgment. That's another possibility as such. Now, therefore, both the judgments are there, and I'm sure the trial court judge has to decide according to one of the two as to what that particular judge feels in that particular situation to the best of it. If it has been considered in the later judgment, to my mind, it is the later judgment which would be binding and applicable to the trial court judge. That's how I would view it, subject to what Justice Nagaratna has to say.
No, conflict in judgments is not a negative thing in the judicial system.
Yes.
According to me, it is an example or an instance of diverse or different thinking on the same legal provision. And a conflict in judgment ultimately leads to development of law, settling of principles, and therefore that is a good sign for the Indian or any legal system. It's not a negative thing.
You are absolutely right. I mean, there is nothing negative about it, I'm sure.
Yes.
Yeah. But the question is, in the hierarchy of courts,
Yes.
the judgment, there are two different judgments, and which is to be followed by the district.
Yes.
Yeah. It is only in that context.
Yes.
Otherwise, I'm sure, that helps in the development of law.
Yes.
Absolutely, the different viewpoints.
Correct.
And, for instance, the same judge takes a particular view in a particular situation and a particular case as such. Later on, a similar matter comes before the same bench. Whether that judge is bound by the earlier view that he has taken or she has taken, the answer is no. One can change one's own view also. I have seen it courts happening. The lawyers, the way the case is argued, the reasoning in regard to that matter, and therefore a different point of view is taken. That helps in the growth of law, and that generates healthy precedents as such for the future, for that matter.
But there's only one aspect I would like to add. There is also what is called as judicial discipline. Therefore, unless a particular judgment could be distinguished robustly, normally that judgment has to be followed. Even a single judge has to follow another. Otherwise, in order to take a different point of view, either you must be able to distinguish the judgment cited or refer the matter to a larger bench.
Absolutely right. That is the judicial discipline. Not only in following the judgments, distinguishing the judgment, and then taking a particular view as such is absolutely part of judicial culture.
Yes.
Judicial discipline and judicial culture, they go hand in hand. There's absolutely no doubt about it. Otherwise, I'm free to take a view. The other judge would say, no, I'm free to take any other view as such. And there would be such a chaotic situation, difficult to manage as such. And therefore, you're so very right in saying judicial discipline, whether it is the judgments or otherwise, conducting yourself in court and house. For instance, now seriously it is being considered live streaming of the court proceedings. There's a serious thinking going on about it. Judicial discipline will be more in action, for that matter, let me put it, if it is live streaming is done. I'm sure that introduces restraint and judicial discipline would emerge in a far more effective manner. That is what is required as such. Live streaming has many pluses for that matter. For instance, they were saying that in constitutional matters, particularly, to begin with, they would have the live streaming once we come into the physical court system as such, with COVID not being there for that matter. Now, in that situation, it would be such an educative aspect of it. Of course, the lawyers across the country, the law schools across the country, the judicial academies across the country would be exposed to such important constitutional matters, live streaming of them. The courtroom is being watched by the future judges, for that matter, in judicial academies. That is something that I am looking forward, which would actually help in playing the role which the judicial academies are required to play, for that matter. That is what I would think of as this aspect as such. I was looking forward to some more questions.
Yes. Sri S.B. Kembavi has posed one question: whether failure to observe rule of law by trial court is justiciable at appellate stage? If yes, how and what is the enabling provision?
You know, I began by saying the rules of natural justice are not the written rules of law. And now, by what provision, if there is a violation of a rule of natural justice? You know, let me put it this way: a fair trial. If a person has not been given a proper hearing in a particular matter as such, there is no provision that a fair trial is not conducted in this particular manner and therefore it is to be struck down. It's not that. It's the accumulative impact on the mind of the judge. If something has been done in a manner which is not in consonance with rule of law, with principles of natural justice, in that situation, I would urge in that background that you have to take the basic issue. Was the trial fair? Was anything missing in that? Any link missing in the fair trial? For instance, a judgment after the trial, if it is not pronounced for a long time, or a judgment does not give the reasons as they ought to be given as such, the appellate court dealing with that particular judgment, even if the conclusion has been rightly reached at, yet it's not a reasoned order. And therefore, natural justice is impacted in that particular context. That is how I would look at it.
Sir, next, Sri, thank you, sir. Aradhya, first additional district judge Ramnagar's question, sir. What is judicial culture towards parties and witnesses before the court?
What is judicial culture?
Culture towards parties and witnesses before the court.
Now, judicial culture towards the parties before the court as such.
Yes.
You know, now parties means the litigants. Am I right?
Yes, ma'am. Yes, sir. Yes, sir. Litigants. Parties means witnesses and litigants.
The litigants as such. You know, question here is the litigant, when appears as a witness, for instance. Now, how he conducts or she conducts himself or herself, that again is in consonance with judicial culture or not. Many things would emerge from this, and the demeanor in which the witness comes forward, conduct of the litigant in court may come in conflict with judicial culture. And therefore, in that context, the trial court judges have to keep all that in mind for that matter. That's how I would view this. Yes.
Sir, sir, the Honorable Justice Hanchate Sanjeev Kumar of Karnataka High Court Judge has posed one question. I read it. How far has the rule of law evolved in the contemporary issues dealing with the conflict of law?
How far the judicial culture?
How far has the rule of law evolved in the contemporary issues dealing with the conflict of law? Dealing with the conflict of law.
You know, let me, if I have understood, how rule of law has emerged in the contemporary situations while being in conflict with law as such. When the import of this question is yet not clear to me, I would like that if Honorable Judge could come forward with the question and elaborate a little, then I would be able to respond to that better. Is it possible to connect?
I will. Gil, whether is it possible to connect the Justice Sanjeev Kumar Hanchate?
We can do, ma'am. We can do. I will send sir a link. Sir would have to click on that link, and then he would be able to join as a. We'll be able to listen to him. So I will. I'm sending a link to sir. Sir, I'm privately sending you a link. Sanjeev sir, you may please click on that link, and you'll be joined on this. Just give me a moment, sir. Ma'am, it'll take, I think, sir, some time. So in the meantime, what you can do?
I will ask another question.
Yeah, you can take another question.
I will pose another question of the. What is the natural justice really means, sir?
What natural justice really means?
Yes.
You know, I used to teach my students natural justice, something which is necessary to do justice naturally. There are certain things, basic things, or let me put it, the basic structure of justice evolves around the mind of a judge. Be not biased, be not prejudiced. A judge can't be a judge of his own actions as such. A judge must hear both the parties before deciding the matter as such. Now, these are the minimum principles that are not written. To say that a judge must not be biased, you don't need to be including this in any particular legislation as such. And therefore, the basics of these two principles, they are most important to naturally flow with justice for that matter. I look forward now from the Honorable Judge.
Chetan Singh, whether we can able to connect Justice Hanchate?
Ma'am, I've just sent a link to sir, and I'm just waiting for sir to join with that link.
Yes,
So,
yes, we will contact him. Sir, another question.
Yes.
Of Sultanabad. Order 45 Rule 15 for sub Rule 4 CPC clearly says no bracket Honorable Apex Court decree or order is inoperative unless specifically directs otherwise. Sir, clarify on this aspect.
You know, specifically this particular provision, its import as such, I have no background of that particular rule for that matter. I need to be, what exactly would be the import of this particular provision to respond to this question?
Ma'am, could you please give my number to sir, or give ask Prashant sir or anyone to give me sir's number so I can talk to him and get him on board? Ma'am, your mic is muted. Right, ma'am.
Sir, the order 45 rule 15 subsection sub-rule 4, unless the Supreme Court otherwise directs, no decree or order of that court shall be inoperative on the ground that no notice has been served on or given to the legal representatives of any deceased opposite party or deceased respondent in a case where such opposite party or a respondent did not appear either at the hearing in the court whose decree was complained of or at any proceedings subsequent to the decree of that court, but such order shall have the same force and effect as if it had been made before the death took place.
You know, I mean, how rule of law is to be interpreted in this kind of a situation as such. It depends upon the factual canvas, and in that background, the application of this particular rule, keeping in view what has been the background of the entire matter. You know, actually, unless I have the particular context of this rule as such, I am not able to make out as to what the learned person, judicial officer asking the question for that matter. You know, if I could directly interact with, then it becomes slightly different for that matter. That is the handicap as such.
Yeah.
In fact, you know, the physical hearing of the matter, that is the judicial culture again, and the virtual hearing of the court matters, that also is part of the judicial culture in that context. And therefore, if we could directly interact, that would be something different. I'm sorry if I have not been able to have the actual import of that particular rule in this context.
Sir, another question. It is our experience in district judiciary that the respect of the bar towards the bench varies depending upon its position in hierarchy, and the court at a lower rung faces more brunt. Sir, please guide the young officers to deal with such situations.
You know, this is interesting. That the respect for the bench depends upon the hierarchy of the bench as such. At each level of the subordinate courts, the district courts, each judge has his or her own respect and status for that matter. As you go up the ladder, that doesn't mean that the respect is at the level at which you're performing. In the sense, you are at the initial stage. If you are performing effectively, you are making the court comfortable. You are giving a fair hearing to the lawyers. The litigants also feel that we get justice from this court. Respect of the lawyers, of the litigants, of the public would be the same for that matter. Question is how you conduct yourself. Question is not at what level you are conducting. At a higher level, they have to deal with different matters. At your level, you deal with a different matter. Respect is the manner in which you conduct yourself. You know, normally in the Judicial Academy, when we are training the judicial officers, we say the classrooms or the academies are to be converted into courtrooms. Knowledge of law is, as I say earlier also, I said earlier, is understandable. I am told there are lawyers at the threshold of their career. They have their ego. And they are not able to manage the lawyers. The management of lawyers is again integral part of shaping the future judges. And therefore, I would say judges at all levels have their respect. It depends upon how you conduct yourself, how you manage your court, how you handle your work as such, how you treat your lawyers appearing in court. Yes.
Yes, sir. Honorable Justice Hanchate, unable to connect, but His Lordship has sent another question. I will try to search and read it. Sir, I will put, Justice Hanchate, sir, with respect to the conflict of judgment in the hierarchy of courts.
Yes. You know, conflict of judgments. As Justice Nagaratna had put it, it's not the conflict of judgments we use, the expression we should be using that. Different view is taken by the different judges for that matter. Now, that is absolutely within the parameters of judicial culture, judicial discipline. For instance, one particular judge sitting singly deals with a particular matter, takes a particular view. Now, if there is a judgment of the Supreme Court or a judgment of the division bench of the same High Court as such, of course it's binding on that. And therefore, if another judge dealing with a similar kind of a matter deals with the same judgment of the Supreme Court or the division bench judgment of the High Court, is able to distinguish it and take a different view, distinguishing that particular judgment. It is in that context, I would not say it's a conflict of judgments. Different views are taken, which is healthy for judicial culture, for developing the law for that matter. And yes, both those judgments can go on appeal further, and it would be sorted out as to which particular view is considered to be in consonance with the view taken by the Supreme Court or the division bench of the High Court for that matter. And therefore, I view it from this angle that it's healthy to take different views and not to say it's conflict of judgments as such.
Thank you, sir. Yashwant Kumar's question is there any book which guide as how to be calm even the arguments are going wrong?
See, judicial culture is not taught by the books. It is something which you nurture over a period of time by being a judge. For instance, to be calm when the lawyer is agitated as such. I have a recipe for that, and let me share that. If the lawyer is aggressive and is not following the judicial discipline as such, adjourn the matter. That's the best way to deal with that situation. Adjourn the matter so that let the temper be cooled down and taken on some other date as such. Otherwise, see, these things are not contained in the books. I normally say in judicial education, senior judges come and share their experiences with the younger judges. This is real judicial education. And similarly, judicial culture, different situations do come up in courts. And therefore, with your cool mind, for instance, the lawyer is aggressive, if the judge also gets aggressive, you would end up where? Judicial discipline would be absolutely go for a sixer as such. And therefore, if a situation which is not congenial and proper, adjourn the matter, take it up on some other date, things would cool down for that matter.
From Telangana, Junior Civil Judge T. Durga Rane, question is, please explain regarding justice not only to be done, but justice need to be deemed to be done with some of your experiences.
Good. I'm happy that you are asking this. Justice to be done, not only to be done, but must appear to have been done. Now, this is a principle which is universally followed as such. You are dealing with a particular matter. You are not giving proper hearing to the parties as such. Or you've heard one side and you're deciding the matter without giving a full hearing to the other party. You must have reached, or you may have reached, the right conclusion. Decided the matter on merits as such, there is no doubt about it. But the party goes with a feeling, if I would have been heard and heard properly, probably the decision would have been otherwise. And therefore, there are numerous situations. Justice is not only done. You may have done justice, but the manner in which you have proceeded with the matter, dealt with the case as such, whether that gives an impression that you have done justice or not. Let me share with you a particular example. It's an old example. Justice Badruddin Tyagji was a judge of the Bombay High Court way back in the year 1895. He was known for deciding cases fairly, objectively, honorably. Two of his sons were lawyers, and invariably the two sides would engage both the sides, one on the petitioner's side and the respondent, the other side as such. He would decide, Justice Tyagji would decide the matter on merits, not bothered about which particular son is winning that particular case as such. Now, he may be doing justice, but it does not appear to have been done. The very fact that the judge's sons are appearing in the matter it demonstrates that actual justice is not being done in that particular context. That is how I would look at it. I'm happy that you are now connected.
Yes, yes. Sir, one CM Joshi of Principal District Judge of Belgaum. This question is, bringing in judicial culture is responsibility of all stakeholders. Judges and lawyers have equal role. Do not you think there should be a more responsible behavior on behalf of the lawyers? What are the ways to bring in such culture among lawyers?
See, culture amongst lawyers, amongst judges. It is an individual mindset. It's an individual cultivation of culture as such. There are lawyers who are paragon of culture for that matter. They are so skillful, they are so good, they assist the court so well as such. And there are lawyers who are angry minds, aggressive minds, attributing motives. These things are not taught. They are nurtured. They are cultivated as you grow in the profession, maybe as a lawyer, maybe as a judge. And therefore, judges have to learn the art of managing the lawyers. And lawyers have to learn the art of managing the judges. I'm conscious of the fact that lawyers can assist the court better if they know the judge better. Now, you would ask me, what do I mean by knowing the judge? Not knowing the judge otherwise, at a personal level, at a social level. Knowing the judge means knowing the mind of the judge. What that particular judge likes. You tailor your arguments, tailor your presentation according to the mindset of the judge. That is the management of a judge, a lawyer managing the judge. Similarly, the judges knowing well that here is a lawyer who conducts in this particular manner, and he is to be dealt with in this manner. For instance, there are lawyers who would continue to argue and argue and argue, would not like to stop as such. Now, in such a situation, what happens is, I for one would suggest the judge could quietly and tell him firmly, you submit your written submissions, we'll consider those submissions. If he's going on and not coming to any end as such, this is the best way to deal with a situation like this. Submit your written submissions. Whatever you wish to say it in writing. Now, when you have to submit it in writing, you would be careful. You would be applying your mind. You would say, do they not apply their mind while arguing in the open court as such? See, my question is, certain lawyers are, used to behaving in a particular manner. And to deal with them, ask them to submit their written submissions. In any case, judicial culture comes to you as you grow in the profession, as you grow as a judge as such. That's how I would view this.
Sir, another question. Srimati Savitri Kunji, Judge Family Court, Dharwad, asks us, what is the significant part of rule of law and independence of judiciary?
Yes. Independence of judiciary and rule of law. Rule of law is possible only and only if the judiciary is independent. In fact, I should have mentioned this in my initial dealing with this matter. Unless the judiciary is independent, the rule of law would suffer. Why? Independence of judiciary means what? Certain extraneous considerations creeping in dealing with certain matters. Extraneous considerations and rule of law are in conflict as such. And therefore, good that this question is asked. We have to ensure independence of judiciary. And if once we ensure that, rule of law is secure in that situation. That is how the two are linked together.
What the difference between natural justice and rule of law?
What is the difference between natural justice and rule of law? Again, very interesting. See, let me put it this way. Rule of law, we say, the black letter of law. That is, whatever the act says, the statute says, or the rules say, or the regulations provide for. Those are to be applied in deciding the matter. What is natural justice? Certain basic elements which help you to do justice, which help you to uphold the rule of law. I would put it this way, straight. Principles of natural justice are integral part of rule of law. You can't uphold the rule of law if you violate the principles of natural justice. They are like the Siamese twins, inseparable. They go together, they live together, and they make rule of law wholesome if you merge natural justice with rule of law. This is how it ought to be.
Thank you, sir. Thank you, sir. Another question from Pavanesh, First Additional District Judge Kolar. Does pendency of cases for long duration diminishes judicial culture?
Sorry, say that again.
Does pendency of cases for long duration diminishes judicial culture?
See, again, I'm happy that this question is being asked. Long pendency of cases. Is it in consonance with rule of law, with judicial culture as such? Certainly not. I'm conscious of the fact that cases take a long time in being decided, for that matter. I quoted Magna Carta. Justice is not to be sold, not to be denied, not to be delayed. This is part of judicial culture as such. You know, there are two things. Because of the workload being so heavy, it takes time to decide cases. Knowing well the lawyer fraternity to which I also belong, they contribute immensely towards the delays in deciding the cases, adjournment after adjournment after adjournment. That is not judicial culture. Unless we all realize what our role is, how it is to be played. Certainly, delay is contrary to judicial culture. I go a step further. In some situations, a case is heard, it culminates, arguments takes place, and judgment is not written for a good long time. I'm conscious now there is a discipline which is required to be followed. But there are examples when case judgments are delayed as such. And there is an internal system where they can delay the judgment. I'm conscious of that situation. And delays take place at all levels in the hierarchy of courts. I'm conscious of that. After hearing the matter, if the judgment is not pronounced on time, it is double jeopardy. It is against judicial culture. Not only that you're delaying justice, in fact, it goes contrary to the interest of the judge concerned. You would ask me how and why. The answer is simple. If you delay the judgment, motives are attributed. The judge may have been approached for that matter, whereas it may be nothing of the kind. Why give birth to such speculations? And therefore, it is very well said, do not delay. Dependency is a major issue with us, and delaying justice is contrary to judicial culture. There's no doubt about that. A lot of effort is being put in, there's no doubt about it. But then our system works within certain limitations. You can't actually and factually go beyond a particular limit. But it depends upon also individual judges. They can play a vital role in handling the situation. Yes, that's part of judicial culture. You're not audible.
Sir, there are few more questions.
Yes.
Answers are already, there is a repetition is also there. Due to constraint of time and giving respect to the age of the honorable speaker, from last to nearly more than one and a half hour, speaker is speaking. I am posing only last question. Patience, which is
comfortable. So far as I am concerned, I'm happy about it.
Patience, which is inherently embedded in judicial culture, does it have any boundaries to demarcate? To be specific, to what extent patience play a role?
To what extent patience
play a role in judicial culture?
You know, again, I'm happy that this question is being asked. Patience, how it plays a role in judicial culture for that matter. A patient hearing for that matter. Patient, a judge is so patient as such. It's an attribute of a judge to be patient. But patient to a limit, not unlimited patience. You don't have to exhaust the patience of a judge. There has to be an end to that as such. And therefore, in that situation, Yes, a judge has to learn the art of stopping a lawyer at the right time. Patience is not to be misused by the lawyer. Time of the court is very important. And therefore, again, it depends upon how a judge manages his court and does not let his patience be exploited by the other component of the court system as such. Secondly, patient judges are able to be more productive. You would say, how am I using this expression productive? In one of the seminars, it was said, judiciary is the most non-productive organ of the state. I was aghast on hearing this particular. The judiciary is the most non-productive organ of the state. Imagine the kind of work, the workload which is carried out. The judges have to work in different shifts, morning, day long, again in the evening for that matter. And therefore, this has to be seen and not to be allowed to be misused, the patience of a judge. Impatient judges are again a threat to rule of law. Pardon my saying this. When you are impatient, when you're not wanting to hear the party, what would suffer? The rule of law would suffer in that context or not. And therefore, patience is integral to judicial culture, which helps in building up rule of law and upholding the rule of law. But the two components, the lawyers and the judges, they have to play a role which helps each other in making the rule of law blend with judicial culture as such. Thank you.
With permission, can I present another question, sir?
Yes, please, please.
Okay. Junior Civil Judge of Sri Ramesh from Telangana poses, please offer your insights on the aspect of impact of legal culture, popular culture, and popular legal culture on judicial culture.
Very interesting. Legal culture, popular legal culture, and judicial culture.
Yes, 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 sir.
See, legal culture, judicial culture, how do we distinguish the two? Of popular legal culture as such. See, legal culture obviously means the conducting of the courts, court conduct inside the court and even outside the court also. I do not really see much of difference for that matter. Legal and judicial culture, you can distinguish it by saying legal culture, that is the lawyers. Judicial culture, the judges. It's a coparcenary of different cultures. The legal culture, the popular legal culture, the judicial culture. This coparcenary, different components, but ultimately the goal is one: to make justice move smoothly, to be carried out effectively as such. The lawyers have to realize that they have to cultivate a particular kind of legal culture. Popular legal culture, lawyers, popularity. Now, popularity would depend upon what? How a lawyer performs in court. I know of cases where the litigant goes to the court, sits on different days in the court, watches the different lawyers playing their role, and then after doing this exercise for 2 weeks decides which lawyer to be engaged. This is legal culture, or popular legal culture. You know, a lawyer is also on trial. He's on test every day in every case before the court. How he conducts, manages, deals with it. You know, a courtroom genius, a lawyer, a courtroom genius, a judge, a courtroom genius. I know of lawyers, perfect courtroom genius as such, elevated as a judge, equally or even better courtroom genius judge. I have known lawyers, brilliant lawyers, but utter failure as a judge. And therefore, one has to cultivate the legal culture, the judicial culture, as you grow in your profession, in your role as a judge, for that matter. Yes.
Thank you, sir. Another last one, in another question.
Yes.
Yes. What kind of programs are to be undertaken to achieve peak point of judicial culture?
Say that again, I didn't get you. Please.
What kind of programs are to be undertaken to achieve peak point of judicial culture?
What kind of programs are to be organized to
achieve peak point of judicial culture?
Nurture judicial culture. Is that right?
Yes, yes, yes.
Right. You know, it's again a very good question. And it's a challenge for the judicial academies. We have to shape the future judges. That's the challenge for the judicial academies. And shaping the future judges actually means what? Building up their judicial culture in that context. Now here, what can be done is there is a need for workshops on judicial temperament, judicial communication, conduct inside the court, conducting outside the court as such. You know, this culture is to be, first, if you say to be taught as such, yes, they are to be apprised of it. They are to be given an adult dose of judicial culture in different situations as such. Documentary movies reflecting upon the shaping of the judges as such, happy minds to be cultivated, again, workshops to be conducted. You know, judicial adjudication is a process of judicial culture as such. Right in what happens is young students who come out of the law schools after doing their +2 and 5 years law course, prepare for the competitive examination, selected for the judicial service. You know, judicial service, only the fortunate ones get the opportunity to do that. But then they have to be mentally prepared. There are many who think, oh, I am a judge. A judge is something which is a paragon of power. The power goes to the mind of the judge as such. The ego. You want to play a display on your car, judge, it's written. See, these are things which you have to bring to their notice through conducting workshops, other sessions as such, senior judges coming and sharing their own experiences in conducting the court, judicial temperament. You know, this is something which comes with experience. You handle situations, you make up your mind to deal with certain situations as such. No one is a born judge. And therefore, the qualities of a good judge, be a good human being, the rest would follow as such.
Thank you, sir. Now I request our senior faculty member, Sri Diminishes, to render vote of thanks. Handing over to Diminishes.
Sir, your mic needs to be unmuted, sir.
ಮೇಲೆ ಬಲಗಡೆ ಇದೆ ನೋಡ್ರಿ.
So there's a small icon on the top, if you can see, in shape of a mic. You can click on that.
Yes, sir, mic off.
So now we can
Yes. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರಗಳು. Am I audible now?
Yes.
Yes. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರಗಳು. Good afternoon to all. Now we have reached the concluding stage of this webinar on judicial culture in aid of rule of law. Now it's my great privilege to offer vote of thanks. My Lord Honorable Justice Srimati B.B. Nagaratna, Senior Judge, High Court of Karnataka and President of Karnataka Judicial Academy, was kind enough to set the tone for the rest of this webinar by addressing all the participants initially. And it is Madam who is instrument in organizing this program. I extend my heartfelt thanks to my Lord Honorable Justice B.B. Nagaratna. Thank you, Madam. The Honorable Judges of the High Court of Karnataka and Governors of the Karnataka Judicial Academy and the Honorable Judges of the other High Courts have participated this program. I extend heartfelt thanks to all the Honorable Judges of High Court of Karnataka and Honorable Judges of the other High Courts and to the Honorable Governors of the Karnataka Judicial Academy. I think it's my great privilege to extend sincere thanks to Honorable Speaker Shri Balram K. Gupta, Director Academics, Chandigarh Judicial Academy, who was kind enough to speak on this important concept, judicial culture in aid of rule of law. His kind self during his speech brought to our notice various instances that had taken place before the various high courts and even before the Honorable Apex Court. Honorable Sir said that judicial temperament is integral part of judgeship. Honorable Sir also said that mutual respect is also integral part of judicial culture and judicial success. I profusely thank Honorable Speaker Shri Balram K. Gupta. Thank you very much, sir. I also extend sincere thanks to Shri Chetan Singh, official SEC online, for facilitating us in organizing this webinar. And I also thank our beloved Director Madam in initiating this program and conducting this program in a wonderful manner. Thank you very much, Madam. And I also thank all the participants who attended this program. The participants also posed a question to the learned speaker, which in my view threw much light on the concept of judicial culture in aid of rule of law. Lastly, I also thank one and all who are directly and indirectly responsible for this organization of this program. Thank you very much.
Thank you.
Can I say a word?
Yes,
Yes, sir. Please, sir.
I'm grateful, my expression of gratitude that this opportunity was given to me and I could share my thoughts on a topic of this which needs to be cultivated further as such. The Honorable Justices of the Karnataka High Court and some of the other High Courts and the judicial officers of the Karnataka District Judiciary, coupled with the judicial officers of other states courts. You know, one advantage of a webinar is the reach out is much larger as such. Though you can't interact face to face for that matter, but the reach out is much larger. And that's the plus for the reason. Speaking for myself, I have enjoyed for the last 55 years physical classrooms, physical courtrooms. And this is something which I'm a stranger as such, but over a period of time, I've learned to be faceless as such while facing the audience as such. It's a pleasure. I've enjoyed my interaction with you all. Grateful for providing me the opportunity. And Chetan, as always, has been always so helpful in monitoring the entire webinar for that matter. I'm grateful to the director and the faculty member for giving the expression of gratitude. You know, this is what we owe to the judicial officers. And if we would not do that, who else would do it? Thank you so much for giving me this opportunity.
Thank you, sir.
Thank you.
Thank you, sir.
Thank you, everyone. Thank you to all the members. This session, as we said in the starting, this session was getting recorded. The recording of the said session would be available on the Karnataka Judicial Academy website by Monday or Tuesday. So, and you can also review the same meeting by clicking on the link that you're joined in today with. Thank you so much, sir. And with everyone's permission, we will end the session now. Thank you so much.
Okay, thank you.
Have a good day.
Thank you.